bill, what I see is that it clarifies 746 and the fact that it clears up the inconsistency of enforcement of 746. Is that not what 585 does?
I believe it
I mean, it
clarifies.
just clarifies 746. You take that bill and lay this one beside of it, and it clears up the inconsistency in the enforcement of 746 because we have a lot of inconsistencies across the state when you go from county to county when it comes to 746. This takes away those. This would clarify that.
Well, you're not asking me a question, so I'll respond if you.
I mean, it's more like a backup.
Well, I think it was. I can certainly does a couple of things differently. One, 746, it's only lawful if you have lawful intent. Well, I agree, it's being interpreted different places, but the act itself says you have to have lawful intent to be able to carry. This does not mention anything about intent. So I think that's the difference. And then I don't know what, when it says it's notwithstanding other state laws. I mean, 746 is, you're subject to the parameters of a concealed carry.
That was in the opinion.
No, that was in a bill we passed a few days ago.
And the Attorney General's opinion on that was what?
I don't think, to my knowledge,
Did you not issue an opinion on that part of the bill?
she hasn't issued an opinion on this bill we just passed. Now, I'm not sure if she issued an opinion on whether or not they were subject to the same restrictions as concealed carry. But we just passed a bill that made anyone carrying under Act 746 subject to those same restrictions. I don't know if this bill, I don't know. If it's not otherwise prohibited by the laws of the state, I don't know if that just means that a felon can't possess it or if they're subject to the concealed carry restrictions. If they're not subject to the concealed carry restrictions, then I have a problem with people carrying, and that means private businesses can't even resist. You have to be able, you'll carry wherever you want to carry, and even the business owner can't stop you. So I think it does more than clarify.
But it still says otherwise prohibited by the laws of the state.
I know,
The laws, we already have existing laws about guns and where you can and cannot take. Those laws are there. When you get your concealed weapons permit, you know the places where you can and cannot take. They're given to you when you get your
and I
license.
think Senator Rice is correct, and I share Senator Garner's concern that that's going to be interpreted by a court. What that means.
Well, we would have to change our whole concealed weapons permit process. If that's the case.
I don't know.
That concealed weapons license lays out the exact places where you can and cannot take firearms. And that supersedes anything that we can write. That's already law.
No,
It's statute.
I mean, the court could interpret this if he or she is not otherwise prohibited by the laws of the state from possessing a firearm.
But I'm talking about the places where you can.
Well, I know, but it doesn't say possessing a firearm and where they can go with that firearm. It just says possessing a firearm, so that very well could mean that only if you're a felon are you not allowed to possess a firearm. Otherwise, you can possess it and you can carry it anywhere you want. Even if the private party doesn't want you to carry it to their store or bar or church or private school, private college. So, are there any other questions?